This is my pleasure to introduce today's interview with one of our star professors, Professor Paola Gaeta, who is a member of the Department of International Law. Welcome, Paola.
Thank you, Grégoire, and thank you for having me today.
So you are the specialist at the Institute of this question around which this issue of global challenges is organized. As you may know, global challenges is usually taking debates that are very actively discussed in academia today. And it seems to us that although the question of genocide is a difficult question and one that has been quite divisive over campuses over the world, it was for us almost an obligation to provide some highlights and historical perspective on the development of this concept and these different uses, and no one at the Institute was better situated to give us your light on this question. Indeed, you after a dissertation in Florence at the UI, you have worked as legal assistant on a special tribunal on ex-Yugoslavia. You've also written an edited volume on the UN Convention on Genocide. You also provided ample commentary on the work of the International Criminal Court. So it's really a pleasure and an honor to have you today. Maybe to situate the context of the conversation today, it may be worth making a flashback and go back exactly at the time in the 90s where you were preparing your dissertation and started working on the question of genocide in the context of former Yugoslavia. Maybe you can tell us whether this was seen as a useful concept for the international law community, especially in international humanitarian law, and what was the precedents that were thought of at the time.
Actually, my PhD thesis, if it's the dissertation you're referring to, was not on genocide, to tell you the truth. It was on totally different matter. But the years while I was a PhD student at the European University Institute, it was between 1993 and 1997. In that period of time, I was also for 1 year a legal assistant at the International Criminal Tribunal for the former Yugoslavia. These were very important years for the issue of genocide. For which reason? The first reason was linked to the fact that the war in Bosnia was going on. And for the first time in history, since the adoption of the Genocide Convention by the United Nations General Assembly in 1948, a state, namely Bosnia-Herzegovina, brought about a case against another state, the then Federal Republic of Yugoslavia, claiming that the Federal Republic of Yugoslavia was committing genocide in the territory of Bosnia-Herzegovina. So there was a first interstate case based on the Genocide Convention on allegations of genocide committed by a state in the territory of another state. At the same time, in 1994, the International Criminal Tribunal for Rwanda was created. And this was a tribunal which was created primarily as a reaction to the genocide that was committed in 1994 against the Tutsi, alongside an armed conflict that was fought at the time. And in 1998, for the first time, the International Criminal Tribunal for Rwanda issued a judgment on genocide against the at the time, burgmaster of a town, Tabe, in Rwanda. It is the mayor of this village, which has been the first judgment on genocide at international level. So it's the Akayesu case. So these were years, the 90s, where genocide left the garage, as I said in a recent article for the Globe, the Institute Review, and started its trip within courts.
And then at the time, you said that the two states were under a different situation. In one case, the genocide and the risk of genocide was ongoing, whereas on the other case, it was more retroactive. from that point of view, what do you think were the lessons learned? Could actually a case placed in an international court had a positive effect to actually prevent the genocide from taking place? And what was the effect judged on the ability for a country to move past the genocide and repair a collective destiny? Was the case of Rwanda interpreted differently than the case of Yugoslavia?
Thank you for this, because one common, I would say, mistake or misunderstanding about genocide, at least in legal terminology, is that genocide means the destruction of a group, because we have in mind the Holocaust. But genocide, legally speaking, it is preventive in nature, namely what you may punish or you may consider to be unlawful in the case of states is the fact that a few acts are committed. These include murder, inflicting serious suffering, mental or bodily, on members of the group, conditions of life calculated to bring about the physical destruction of the group, and so on. And all these acts must be accompanied by the intent to destroy the group, in whole or in part, as such. So you don't need to accomplish the destruction of the group before speaking of genocide. So that's because you don't want to wait until a group has ceased to exist to be able to speak of genocide. So you see the preventative aspect of the definition of genocide. So when I say that in Bosnia was accusing the Federal Republic of Yugoslavia of committing or being about to commit genocide. Genocide had been perhaps already committed, although the court did not find this was the case only for Srebrenica. The court in the end found that genocide was committed only in Srebrenica and not by Serbia, but by the Bosnian Serbs, the VRS, this was the name of the group, which was not acting on behalf of Serbia. Now, going back to the question, what lessons we have learned, unfortunately, the lesson that we have learned from the International Court of Justice cases, the one Bosnia versus Serbia, but also the following one, Croatia versus Serbia, still on allegations of genocide committed by Serbia in the territory of Bosnia or Croatia, is that the court has been ready to open the Genocide Convention to interstate disputes, to hear allegations of genocide committed by states, which was not a given fact. It was an interpretation of the convention by the court. But unfortunately, in both cases, the court has put the threshold of evidence very high. Namely, it has said that since this is a serious allegation, the claimant state, so the one alleging the commission of genocide by another state, must bring highly conclusive evidence that the other state is acting with intent to destroy a group. And this is a very high standard of evidence that the claimant has to prove, which is not very easy to prove, in particular when genocide is committed during warfare. Because during warfare, you can always interpret that certain acts may be not highly conclusively driven by the intent to destroy the group, but rather that they are driven by the intent to militarily defeat the enemy. So the lessons that we have learned from the ICJ so far, the International Court of Justice, that the standard of evidence is very high. The highly conclusive evidence must be proven, which is very difficult to be proven when alleged genocide violence occur during armed conflict, because you can infer from the context that there is no intent to destroy the group, but only the intent to destroy militarily, to defeat militarily the enemy. We have to wait now and see what the International Court of Justice will decide in the Gambia versus Myanmar case. It's a case that will be heard in the merits next January, February 2026. And there are allegations that the government of Myanmar has committed genocide against the Rohingya people. And there is, as we know, another pending case before the International Court of Justice, South Africa versus Israel, for the alleged genocide committed by Israel in Gaza, and also public and direct incitement to commit genocide in Gaza. So the lessons to be learned for the International Court of Justice is not a very interesting one from my point of view. While when it comes to genocide to be proven in criminal courts, here you have the responsibility, the criminal responsibility of an individual, which is at stake. And the lessons that we have learned from the jurisprudence of the International Criminal Tribunal for Rwanda, but also from other cases that have been decided at the national level, is that proving the genocidal intent of an individual, it's easier when you are able to prove that there exists a genocidal policy by a state or a non-state armed group. So in the case of Rwanda, the Criminal Tribunal for Rwanda had first determined that what was happening in Rwanda in 1994 was a genocide orchestrated by the government, and therefore it was easier to find individuals responsible for genocide as a crime, because they may prove more easily that those individuals were participating in this state policy. The same may be said for the situation of Srebrenica. Once you have determined that what happened there was genocide, then it's easier to prove the criminal responsibility of an individual, and so on and so forth.
So thank you. You talked about the two pending cases in front of the ICJ, and you talked about the two special tribunals. Has the debate changed the way the concept of genocide has been used when we look at jurisprudence coming from these national courts, where maybe allegations have been litigated in between the two periods, the 1990s and the 2020s? And what role has jurisprudence of the ICC played also in changing the articulation between international humanitarian law and the question of genocide?
This is a broad question. Let me tell you, first of all, that the orthodox approach to genocide, to the definition of genocide, has been defined by the Genocide Convention in 1948, is a bit deaf from other disciplines, because it seems that the definition of genocide applied by lawyers or used by lawyers is different from the definition of genocide that sociologists or political scientists or historians would use, or in the field of genocide studies. Lawyers are very much criticized because they seem to apply a definition that has no realistic connection with what happens in the field. Think, for instance, of the debate around whether or not in Cambodia there was a genocide. Many historians would have no doubt to tell you that what the regime of Pol Pot did in Cambodia at the time was genocide. But if you apply rigidly the definition of the Genocide Convention on Genocide, the lawyers would tell you, no, this was not genocide. And indeed, the special chambers for Cambodia have not found that the atrocities, incredible atrocities committed against the Khmer by the Khmer Rouge, they found that it was not genocide, but they were just crimes against humanity or war crimes, while genocide had been committed only vis-à-vis the minorities in Cambodia, namely the Cham and the Vietnamese groups there. So that's the first thing that we have to say. And unfortunately, the jurisprudence of the International Court of Justice or the special tribunals that you have mentioned, they've aligned themselves to this orthodox approach, with some, perhaps here and there, certain deviations, but still the prevalent jurisprudence has been a bit adamant to say that genocide consists in the commission of a variety of acts with intent to destroy a group, but to destroy means to destroy the group physically or biologically and not as a social unit. On the contrary, the same may be said for the International Criminal Court, that so far has not issued any decision on genocide, not yet. There is a case pending against the former president of Sudan, Omar al-Bashir, including for genocide charges. Al-Bashir has not been yet apprehended by the court, and therefore there is no trial against him. But so far there has been no other genocide charges before the International Criminal Court. But what the court has said so far on genocide is strictly aligned to the previous jurisprudence of the International Court of Justice and the ad hoc tribunals. So not very much, let's say, progress has been made so far at the International Criminal Court.
So what you're saying is that the debate with other disciplines has yet to take place at the level of its impact on the work of courts. But what do you think is the impact of the debate, for instance, the historiography on the Shoah, which has been completely changed since the 80s, where there was a turn in the 80s and to today on the micro-level practices and the everyday practices of Einsatzgruppen, for instance, and a lot of literature that is much more grounded at the micro level than at the level of state intent and unitary state. Do you think that in the academic community of international law scholars, not particularly in those who sit in the courts themselves, this debate has changed the international law discipline, or not yet?
No, I think that not at all, and it's unfortunate. As I said, what we have to consider, and it's not me having said so, but a sociologist Martin Shaw, who has written a lot about genocide, in particular genocide and war. What he has noticed that, of course, genocide being a social phenomenon, first of all, the legal definition of genocide had been drafted in 1948 because it was very much pushed by Raphael Lemkin, who wanted to have a legal definition of genocide in a treaty. Raphael Lemkin, as we know, is the Polish lawyer who has invented the term genocide. Well, the legal definition of genocide has been adopted without enough sociological reflection of what should have been this definition. So there has been, since the beginning of the definition of the genocide in international law, some sort of disconnect between the legal practice of genocide and the practice in other disciplines. So no effect has been had so far. The debates, or whatever debates on the Holocaust or the historiography of genocide during the Shoah and so on and so forth. As I said, international lawyers tend to be a bit deaf when it comes to other disciplines, as if they have to protect the pureness, I don't know if you say pureness, the purity, thank you, the purity of genocide, as if you could contaminate this notion. And most of the time they would tell you that, well, there are other crimes that can describe similar tragedies, such as crimes against humanity and war crimes. So why should we dilute the notion of genocide when you can call what happens, the different atrocities mankind is capable of committing, we can call them crimes against humanity. I totally get mad when I hear these kind of objections, because we know that law exists to put exact labels on human facts, and genocide as an interest that is protected by the prohibition of genocide is the right of group to exist. While crimes against humanity is the prohibition of committing massive and systematic violations of individual human rights. Perhaps only in crimes against humanity you have the protections of group rights through persecution, that is the denial of fundamental human rights on discriminatory basis, but still you don't protect the right of groups to exist. So I don't think that we shall be happy to say, well, this atrocity can be called by crimes against humanity, when the atrocity in question, after all, is committed because there is an intention to destroy the group. So I don't buy the argument that is made.
Has the crime of genocide ever been used at the local level, at the national level, in different formats, either truth and reconciliation mechanism or domestic level tribunals where the crimes have been taken place? And are there any examples of whether naming this crime as such has helped people move out of the atrocity and repair its collective destiny.
In particular, this has happened in Rwanda because with the end of the war in Rwanda and the Tutsi minority went back to power, the government of Rwanda wanted to punish all the people responsible for genocide against the Tutsi, mainly from the extremist Hutus. And therefore, not only they supported initially the creation of the International Criminal Tribunal for Rwanda, but they also went on internally to face what happened. And they did it in two ways. First, by alternative mechanisms of justice, the famous gacaca courts, which are grass courts made by people, not in a formal trial, but just so that every perpetrators could be called to account in front of the community to explain what he did and why he did it and to apologize to the community. And so there was this process of healing through this alternative mechanism of justice, but also through the ordinary trials, because they passed the legislation to punish the genocidaire through courts, through criminal trials, and they did it so. Now, to what extent this has helped the reconciliations in Rwanda, I think that we need a bit more of time. I mean, it is already past a lot of time, but it's not so much, I think, for historiography to have a total full account. Genocide happened in 1994. I think more time should pass. But in Rwanda, there has been an attempt to use the genocide trials and the genocide proceedings to heal with the past.
Do you see similar mechanisms being proposed in the cases where allegations of genocide have been placed in front of international courts, whether it concerns Myanmar, whether it concerns Israel and Gaza, or whether it concerns Russia and Ukraine?
Of course, it depends on the different circumstances. In Rwanda, the genocide was internal to the state, and there was a change of government, a change of power, so that the victim group had come to power. So the situation was different. While, for instance, I think that the question of genocide, whether or not it was genocide, has remained there when it comes to Cambodia, as I said, because the victims, the Khmer, thought and believed that they had been victims of genocide, but this has been not recognized internationally as a genocide, or legally has not been recognized as genocide. But there is, and on the contrary, in their case, I think it was a French journalist who coined the term self-genocide, as if part of the own population, the Khmer Rouge, had committed a genocide against themselves, the majority Khmer. And of course, they don't like the term self-genocide because they consider that the stigmatization of a different kind of social groups, the majority of Khmer, for the creation of a more just community, which was the ideology of the Khmer Rouge, for them transformed the Khmer in the eyes of the Khmer Rouge in an enemy group, in a group, different from them. And indeed, they said that you have a body of a Khmer, but you have a different mind of a Khmer, and therefore they try to exterminate them. So this process has not been done, for instance, in Cambodia. When it comes, on the contrary, to genocide that are committed by governments or actors in the territory of another state, the process of reconciliation is more difficult because you have also to involve two states. No? What I wanted to note, however, that it's easier, I've noticed, at least in my study, that when it comes to find out whether or not there exists a policy of genocide, in the context of a war in particular, it seems to be easier to find this genocidal policy when it is a non-state armed group committing violence, such as in the case of the Islamic State vis-à-vis the Yazidi, while it becomes more difficult, for instance, to call it genocide if it is done by a government, I don't know, Israel, against the Palestinians in Gaza.
I have a last question that maybe will interest our audience, is that we are located here in Geneva, in the heart of the, we could say, the capital of international humanitarian law, and you are also the director of the Geneva Academy of International Humanitarian Law and Human Rights. And I wanted to know what you think is the terms of the debate from Geneva on this question of on genocide. How is Geneva and the spirit of Geneva and the humanitarian tradition affecting how we see this question and how we read this question today, and what are the levels of action that exist when you are a professor in Geneva rather than in other city of the world?
It is really interesting here because, as you said, Geneva is the capital of international humanitarian law in particular, namely the body of law that applies in armed conflict, okay? And then it depends whom you ask. But in particular, as I said, when there is violence in wartime against a particular group, think of the situation in Gaza or think of other situations as well, including in Myanmar vis-à-vis the Rohingya, international humanitarian law would apply as a body of law regulating armed conflict. And there is a sort of reticence in most of the time, finding, as I said, the existence of a genocidal policy during war, because you say, well, it's just war, it's not genocide. So paradoxically, the fact that there exists a spirit of international humanitarian law, this plays against the findings of genocide in most of the cases, because you want to try to justify the violence through the lenses of the applicable law, which is international humanitarian law. While I think that the rules of international humanitarian law, particularly when it comes to conduct of hostilities, bombing, targeting, and things like that, they do apply concurrently with the prohibition of genocide. But the rules of international humanitarian law are just prohibitions, so they tell the belligerents what they cannot do, which means that if they, let's say, comply with international humanitarian law, this does not make that the act is lawful, because they may be genocidal. I give an example. If during a war against a terrorist group, for whatever reasons, there are attacks against the enemies that cause collateral damages against the civilian populations, which means that innocent civilians dies in great numbers also. You may say, well, but this is not unlawful under international humanitarian law because it's a proportionate attack under international humanitarian law. You have to prove that it was not disproportionate to talk it unlawful and therefore perhaps genocidaire. I think that the fact that it's perhaps lawful under international humanitarian law does not make any difference, because simply may be not prohibited by international humanitarian law, but still may be genocidal. I don't know if I explain myself. Yes. It's very complex, but it's the relationship between two bodies of law that is at stake.
Thank you very much, Paola, for your time and for your helpful thoughts on this issue.
I don't know if it were helpful, but thank you for having me.